Welcome. Again, we are going to speak about arbitration and what an arbitrator should do. And these are called the arbitrator's 9 points. I've assembled these from experience. I'm going to look at my notes and read it out to you quickly. 1. Impartiality. 2. Independence. 3. Avoidance. 4. Consent. 5. Roadmap. 6. Shut up. 7. Speed. 8. Structure. And 9. Relief. Let us dive straight into impartiality and independence. When a number of people get together and appoint you as arbitrator, you have to be impartial and you have to be independent. Impartial means you cannot take sides. You cannot favor the one side over the other. You must do justice between the parties. You mustn't rule in favor of your friend. Independence means you must keep away from both these people. The third thing I want to speak about is avoidance. One of the parties or one of the counsel or one of the witnesses is your best friend. His daughter is getting married and you were the godfather for the child. Don't go for the wedding. Do not go for tea. Do not visit him in his house. If you are going for the annual general meeting of the bar and you see him 30 feet away and he's making his way towards you to shake your hands, run like hell in the opposite direction. All it needs is one photograph, one WhatsApp message, and you're done. Move on to consent. When the parties want to do something and they are having a dispute, we want to start the proceedings in this way. We want to bring so many witnesses. We want that person is expert. We want this discovery of documents. Make the parties agree to the procedure. Make them sign a document. When there is a dispute afterwards, when you've given your final award or some interim award, that consent order will save you. Next point is roadmap. The moment the parties come before you, give them a complete roadmap. This is when you will send the statement of claim. This is how the statement of claim should look like. So many days defense, so many days reply and rejoinder, so many days filing of bundles, all of that. Give them a roadmap and say final arguments in black and white filed on this date. Don't depart from your timetable or roadmap until both parties agree. Of course, if both parties agree, then you can extend the roadmap left or right as you like. And here's my favorite rule. Shut up. When one of the parties is submitting, don't make clever remarks. Don't move backwards. Don't take off your glasses. Don't make any visible signs of disagreement. Sit as a statue. No twitching of the muscles, rolling of the eyes, looking up. None of that. Everything is being recorded. Somebody is writing it down. They will go afterwards and say, this guy is one-sided. Next, speed. Don't take 3 years to write an award. Do the award as quickly as you can. If you're having difficulties, speak to the parties and take different positions for each award. Break it down into parts. Next is structure. Structure is also like a roadmap. But this structure is a different structure. Whenever the parties argue before you on any point of dispute, first of all, define the dispute. Is it within your jurisdiction or does it fall outside your jurisdiction? Is it possible 90% of the dispute falls within your jurisdiction, 10% just falls outside? Then you have to get their consent to expand your jurisdiction. If they do not give you consent, identify why you can or cannot make the decision on that expanded jurisdiction or the thing that falls outside your jurisdiction. The next thing is, when you're considering arguments as a result of a trial, you must actually set out what the dispute is, what is the issue before you, what is the evidence of the parties, what the claimant argued, what's his evidence, what's his law, what the respondent argued, briefly. And then you must analyze, you must cook the evidence. There are valleys and peaks in all the evidence, and you must say, I believe the respondent because this is important, this evidence is pointing in that direction. Set out the evidence. If you do not agree with the other side, say, I cannot accept the claimant's evidence. Set it out because 1, 2, 3, 4. Because if it's a multi-billion-dollar dispute, instead of paying the winning side his billions of dollars, the losing party will go to the High Court and try his luck. He will say you are not impartial. He will say you didn't pay attention to this important point. You're only as good as the paper on which you write your award. The last one is relief. Usually what the arbitrators do is they will give a final award where they give an award for liability, an award for quantum. If the winning party establishes liability, then they will give interest and then they will give cost. That's fine. But the more experienced arbitrators, what they will do is they will agree with the parties and get a consent order. They will give a first interim award on liability. Then they'll give a second interim order on quantum if there is an establishment of liability. And the final award will be an award on costs and interests and all the other matters. Those are my quick thoughts. Remember what I said. I'm going to look left again to my notes. Impartiality, independence, avoidance, consent, roadmap, shut up, speed, structure, relief. I hope you found this interesting. If you did, please like it, comment below, subscribe, and please share it widely. I hope to see you again at the next episode. Have a good day.